Hi, good evening, everyone. Just give us a minute or two to start while participants join. Okay, why don't we begin? Good evening, everyone. Thank you for joining. Um, my name is Malcolm. I'm the Chief Operating Officer at IDfy. Uh, Today, I'm joined by Ben, who is in some sense, has been there, done that, and seen the entire GDPR journey. I'll request him to introduce himself in a second. And Sumantra, partner at Khaitan and a close collaborator, who's seen the ringside view how the regulation is developed and has perspectives of how this might pan out going forward, especially post May 2027. With that, perhaps Ben and Sumantra, maybe slightly more detailed introduction. Ben, first you, and then Sumantra after that.
Sure. Hello, everybody. So I'm Chief Exec at Securys. We are a global data protection and consulting firm. We've been implementing data protection programs for about a decade and a half now across the world. We operate in about 70 countries, have offices in 5, including one in Mumbai. We've done a lot of work, particularly in regulated sectors like financial services and healthcare, but across a very wide spectrum of clients and dealt with both the initial compliance program and then, of course, the long duration afterwards, which is really what we're going to be talking about in today's session. I look forward to talking to you about that later on. Malcolm, back to you.
Sumantra, maybe quick intro, please.
Thank you, Malcolm. Hi, good evening, everyone. I'm Shumantra Bose, a partner at Khaitan Co, a national law firm, and I'm in the data privacy practice at the firm. I've been practicing data privacy law in India for over a decade, and we've also been involved in advising the government on not only the drafting of this particular legislation, but also with the rules. We've also assisted in several aspects of the stakeholder representations as well. And yes, happy to contribute for this discussion today as we move towards finally enforcement and compliance. Back to you, Malcolm.
Perfect. Thank you. So I think as the title of this webinar says, the idea is, yes, we're working towards May 2027, but at least from the several discussions we're having, at least we believe the real sort of movie starts then, right? When you will have to ensure obviously you're compliant, but prove it and sort of act it out, right? So and that's what the idea of this webinar is about, to really discuss and dissect what would the post May 2027 world look like. And that's where the idea of having Ben, who's sort of, and Securys, who's seen this in other markets, and Sumantra, who has a perspective what it might look like in India, come in. So very quickly, I think Ben has already introduced Securys. Ben, if you want to add anything, and then I can talk about IDfy.
Sure, I think no, I've kind of covered it.
Okay.
I think the important thing is to understand the ongoing operational requirement for privacy. That's what I think both of us are wanting to talk about in this session, and that's clearly where we particularly come in as an operational delivery firm that does long-term privacy delivery for our clients.
Perfect. I think at a 10-second level, IDfy is we call ourselves a trust stack. We've been active in Privy is one of our three platforms. We've been active in this space for a while, including sort of winning NEGD's Innovation Challenge. We're in the midst of nearing roughly 50 odd implementations at this point. And obviously we are a technology platform company, and we're kind of working, helping customers manage and automate their journey to be compliant. If you go to the next slide. So I think this has been the third in our series of webinars that we've done together with Securys. I think we had the first two earlier in this year, and we will continue this. The idea, like I said, of today is to really focus on what does the world post May 2027 look like. I think a lot of our conversations, rightly so, are very indexed on the next 8 months, the next 9 months. But for us, and if you to step back, this is only sort of match practice for the real match, which is post May 2027. And that's what we'll spend time talking about. If you go to the next slide. So Ben, I'm going to hand over to you here, and maybe a couple of slides from your experience of what could sort of people expect. And of course, we'll deep dive a lot more into it in our Q&A right after you finish.
Sure. It's interesting. You've used a couple of metaphors already in this session. You talked about the movie, and then I think it turned into a cricket match. But the reality is that if you're going to use a show business analogy, this is more like a play or a musical, because where we are now, we're writing the script and building the set and doing the rehearsals and getting ready for the show. And then the show starts on round about the 13th of May next year and runs forever. It's like the Mousetrap or Cats or something. This play never stops, and we have to turn up every day and do our part. And it's a part that we do against a constantly evolving background. So it's a play with a lot of improv in it. We're rewriting the script as we go. In terms of what to expect, I think the slide sets out one view of this. I'm really talking about kind of point 3 here, but yes, there is accountability, and yes, some of that accountability will be driven by regulatory attention from the board. But I think that takes time. One of the things that we learned in Europe was with the May 18th, 2018 live date, was that first of all, people made the mistake of treating that as a finishing line. So they built a program and they thought, oh, now we're done. And job one for us today is to convey just how wrong that is. It's the starting point for your ongoing compliance program. But the other was an expectation that the privacy police would turn up on the 19th of May, knock on doors and say, show us your papers. And they didn't, oddly enough, because that's not how it works. What happened instead was a variety of different pressures. Eventually, you get direct regulatory pressure from the board, and that will be focused. They will have enforcement priorities. They will have sectors and activities that they care about more than others, and one can speculate exactly what those might be. And I might defer to our colleague from Khaitan to give us some insight into where he thinks that might happen. The things that come to focus more quickly are, firstly, pressure from your own supply chain. So everybody that you work with will be looking to see that you aren't the weak link in their compliance chain. This is the pressure not to overlook, because if you don't take a leading role in establishing how you evidence compliance, other people will do it for you, and their expectations may not match yours. The second tier to this is other regulators. If you are a regulated entity in another sphere, so if you have a financial services regulator, or regulators plural, or you're in health or education, or anywhere where there has already been a strong safeguarding or customer outcome focus, you can expect to see those regulators paying attention to your data protection compliance, because it gives them another lever. because it's part of your delivering the outcomes they want for your customer base. And that's absolutely been a feature in Europe, that the financial services regulators took the ball and ran with it, to go back to Martin's sporting metaphor and add a different sport, very early on. So you can look out for that. I think the third thing is to remember that data principals acquire rights under the DPDPA, and they will use them. Initially, not individually, very frequently. That takes a long time to build. It's like a slow building tsunami. But every month you will see more access requests, more rights exercises, more complaints, more inquiries. What you do see early on is special interest and pressure groups. So you will see concerted action. We've seen it from unions, particularly in Germany and South Africa and in France. We've seen it from non-profits. You'll all be familiar, I imagine, with Max Schrems's None of Your Business. And they drove a lot of the initial pressure for compliance. And what all of these regulators are looking for, and what you see highlighted in this slide in terms of the penalties, is compliance across the whole picture. The danger is to focus on one aspect of compliance and think that's the answer. In India, that would be consent. Yes, you absolutely need to get your consent management sorted, but it is not by any means the only expectation placed on you by DPDPA. And if you only do consent, you will end up being fined or prosecuted, sued, or complained at and then fined or sued by data principals, because you have not dealt with your transparency obligations, your lawfulness obligations, your retention obligations, your obligations to secure your supply chain. And you can see here that these are some of the many, many, many fines that happened across early years of GDPR enforcement. Some of these fines are very substantial, and they are, none of them, about consent. They are about breach notification, they are about transparency failures, they are about lawfulness of processing, and they are about security. So while data protection and cybersecurity are different things, data protection absolutely requires cybersecurity, and it places a much stronger focus on the effort that you make to ensure that everyone who is involved in your data processing supply chain, both upstream of you, so your suppliers, and downstream of you, people with whom you share data, are compliant and adequately secure. So you need to think about this as an operational transformation that drives continuous, ongoing compliance activity across your whole organization in multiple stacks, in multiple dimensions. Let me hand over there, Malcolm, and leave the floor clear for others.
Yeah. No, thank you, Ben. And I think that's a great context and setup for the discussion we just want to have between the few of us, right? So to the audience, I think we're going to, do a quick 20-minute or so Q&A with both Ben and Sumantra. Please post your questions. We'll try and take a few of them as we go along. And, we've got a, 5-10 minute wrap-up summarization at the end. So with that, why don't we begin? So Sumantra, I'm going to sort of start with you, right? You've been, as you mentioned, involved in sort of the consultation process, shaped the act and the rules. And I think as we are now, the entire theme of this is to talk about what happens post-May. So the first sort of the question I have is the expected to have a digital first data protection board post May. What do you think is the role you expected to play in the privacy ecosystem in India?
Thanks, Malcolm. So, again, I think looking at not only what the black letter of the law is, but also in terms of what the thinking was, right? Why did we get here? Why did we need a completely new law? One of the big reasons, of course, people talk about that 2017 judgment, but the reality was that even with the patchwork of laws that are still there, right? In terms of the Information Technology Act and other rules relating to sensitive personal data information, enforcement and awareness are really Achilles' heels. Even with the laws that you have, there are certain remedies, but rarely are these provisions invoked, much less actually go through the enforcement mechanism. So therefore, the Data Protection Board of India is intended to be an enforcement body, enforcement and adjudicatory body. It is less intended to be a body which will provide guidance and is intended to really strengthen the privacy ecosystem in India. And that's why you see this digital office concept, right? Because too often, courts and other tribunals in India have this enormously complicated process, and also claims take forever to be adjudicated upon. So there is a deliberate attempt to make it easier for individuals to approach the board. And there are also provisions that the central government and courts may also refer matters to the board. So one has to understand that more than, this body providing guidance, what is really intended to be is that it will be the central enforcement and adjudicatory body. It is currently, of course, being set up, and therefore it will provide a fillip for, all matters, all complaints, whatever is there, and also in case data fiduciaries are unable to redress grievances or do not allow for exercise of rights by data principals. All of these matters are expected to go to the board for adjudication. So therefore, it has a very wide role in terms of actual enforcement of the act. Those very large penalties that are there up to 250 crores. Now, while it is not expected, again, what Ben was mentioning as an experience after GDPR, it's not that on day one, someone's going to make a claim and right there you're going to have a 250 crore penalty. But what is going to be important and what is likely to happen, looking at the experience with some other regulators in India, is that a story will build up, right? Over a period of time, this particular board will also understand the posture that is taken by an entity towards privacy, because it will have the information, right? Whatever kinds of claims that are being made, how are they being resolved, etc. So, over a period of time, it is expected that the board, beyond its adjudicatory powers, will also, start looking at the history of a particular entity against whom claims have been made, and thereafter really crystallize its own jurisprudence as to when, how, and how much penalty is levied for offenses, right? Because again, there are penalties for different kinds of offenses. Even for one particular instance, there can be several offenses. So that jurisprudence is also something that the board will take sort of primary responsibility for. Back to you, Malcolm.
Thank you. Ben, maybe I think you were beginning to sort of describe it, right? I think the first 6 months experience kind of, as you were saying, sets the tone for, probably the next few years. So what would be, some of the lessons from, those first few months, the first few perhaps situations, the first few sort of organizations that kind of perhaps got pulled up, and so that's one sort of question. And the related one is the folks who are prepared for the first 6-12 months versus who are not. What in your mind was the difference between such organizations?
Sure. I think that the first thing to say is that historically elsewhere, regulators have taken what you might call a homework-driven view around enforcement. So they are interested in you demonstrating that you have tried to comply. Everybody recognizes that compliance is a journey, not a state, and also that data protection is a matter of judgment. There are things, obviously, at the extremes that are patently compliant or patently not compliant. But most of the time, you're in an area where you're making a balancing test. You're making a judgment about the balance between what you want to do and the rights conveyed by your data protection law. And what the regulator really wants to see is that you have done that and that you did it in advance of your processing. So the first thing I would say, and this also to some extent answers your second question, is people who have built a program that bakes data protection into their thinking, so what we talk about as privacy by design, from the outset, and can demonstrate to a regulator that they properly considered the issues, are then in a discussion with the regulator about whether or not they made the right decision at the time. But regulators have historically taken a very lenient view. If the company can show that it thought it through and it came to a view and it took advice and made decision X, and the regulator feels that decision X wasn't the right decision, then often they've said, well, we can see why you thought that. We don't agree with you. Don't do it anymore. But that's been the end of it. Whereas if they come in and they can see a company that has not paid sufficient attention, did not do the thinking in advance, has perhaps tried retrospectively to paper over the cracks by producing a bunch of retrospective DPIAs or rapidly producing some policy paperwork without any evidence that that policy has been disseminated, trained, acted upon, then they've come down much harder. And many of the big fines have been for organizations that cannot show a proper effort at compliance. So I think, point one would be, if you want to avoid future pain, you need to get the homework started now, and you need to bake it in operationally, because the regulator will look all the way back. They're not just looking at your current state, they're saying, how did you get here? And can you show that you were compliant from the moment compliance was expected? I think in terms of a wider question around well prepared as opposed to ill prepared, this also goes to some of the other reasons to do data protection in the first place. Well prepared companies see data protection as a core activity, not as a compliance silo off in a corner. They think about their record of processing activity as a map for organizational processing. They bring the data protection team into scope with everybody else. They have joint discussions. They have data governance as a high-level activity that covers the whole organization, which then means that they can use the learnings that they get from data protection analysis in a much wider way. So they can look for inefficiencies, they can look for duplicated data and wasted effort, and they can make sure that they're delivering good outcomes for their retail customers, to borrow Principle 12 of UK FCA rules. Those that see it as a pure compliance activity, it ends up being nothing but a cost. It is seen by the organization as a barrier to progress rather than an enabler, and they don't get any synergistic benefit from doing this. So rather than waiting until the last minute and then desperately doing a papering exercise that won't stand up to inspection, you're far better off getting all of this information together, baking it into your processing, and then leveraging it, particularly to think about the modern world. If you want to take advantage of AI is utterly dependent on the quality of input data, the quality of thinking about the processing, asking the right questions and having the right safeguards. These are all things that your data protection team will do as a matter of course. So you need to bake that in to your AI governance and your AI development, again, rather than seeing these as silos that you have around the organization that don't communicate with each other. Malcolm, back to you.
Got it. No, thanks, Ben. So maybe just changing tack, Sumandra, and building on what you're saying. I think you described what you expect in your previous answer, what you expect the board to oversee. But given it's a digital first board, probably expects compliance on demand. What do you think will be the sort of the obligations and of the data fiduciaries in terms of how they have to behave, they have to interact with the board per se, and what kind of sort of evidences, etc., would organizations need to maintain and provide?
Right. Thanks, Malcolm. So, I'll just break this down, and I'll talk about one is from the perspective of internal governance will be one important limb. The second limb will be, of course, your external interaction with your data principles. And number three will be regulatory liaison and management. So these are the three pillars that I'll talk about, and I'll explain what data fiduciaries should really be looking out for under each of these three. Of course, number one is a fairly simpler one, but it tends not to be when an organization kind of doesn't know what it is doing. So what is internal organizational governance, right? It starts off, of course, having with policies. Again, with some policies that people never end up reading, not that kind, right? You've got to understand what exactly you're dealing with. You've got to identify the best people who can help you in this journey. Some of those people will be in your data protection legal team. Some of those people will be from IT. Some of those people will be from information security. They will also be your external advisors. But it really has to start, number one, with is that who in the organization do you hold responsible and for what function when it comes to dealing with compliance? Because this is not going to be a one-day event. This is continuing compliance. You have to have a mechanism not just for preparing for the law, but also compliance on an ongoing basis. So you will require manpower and personnel. This will require budgeting, of course, and then there will be your policy related drafting. And that's again up to the organization. You can have one policy or five policies, but the reality is that what is written in that policy can actually be complied with, that someone can take responsibility. Accountability is a key principle under this legislation, where data fiduciaries are responsible for all data processing activities carried out not only by themselves, but by all data processors in their ecosystem. So you have to also have a mechanism to exercise that same level of governance over any data processor that you're also engaging, right? Now, number two, what are your interactions with your data principals? Some data fiduciaries have a more simpler data processing structure where they might only have, let's say, from employees, right? That's the best case scenario where it's all internal. So less reliance on consent. Other data fiduciaries will have a far more complex structure where there will be individuals over e-commerce platforms, let's say. Of course, there'll be employees, vendors, etc. So you have to set up not only your legal basis of processing in terms of consent, but you will also have to ensure that you're able to effectively comply with any requests by data principals. That could be a very small grievance. That could be, them asking you to erase your data or to update their data, right? What are you doing in terms of putting in systems so that those aspects of compliance can be dealt with? Now, coming to number three, of course, you've done your one and two. You think you're ready for it, and now you're right at the doorstep of full implementation, right? This is where, especially in the first year or so, it's very important to study the behavior of the adjudicatory body. Because again, you're not going to have adjudications on day one. There will be claims. Some will be legitimate. Others will be to really test the waters or to create panic in your organization. So you need to be prepared for that, not just in terms of, if I put an analogy that we have today, a lot of organizations today actually actively trace the dark web to see if there has been any sort of data breaches from their end. Why? Because the regulator, the Indian Computer Emergency Response Team does that. So companies want to stay ahead. So, that is also something that organizations have to start doing, that what kind of claims are being made, what is the attitude of the adjudicatory body, so that over a period of time, you are able to build a sort of liaison or a playbook in terms of how you're going to deal with the regulator based on the kinds of situations that you'll have to deal with. Back to you, Malcolm.
Thanks. Ben, I think I want to go back to something you talked about earlier. I think in the post-May 2027 world, there's, of course, the board, there is sector-specific regulators, there is probably organizations' own sort of boards, etc., who will keep them sort of straight and honest. But to your point, I think the biggest sort of constituents who would probably keep data fiduciaries honest is going to be the data principles themselves, right? And you talked about how obviously they get more educated, and you should expect perhaps a lot more awareness, and then over time a surge of people being active, coming in, checking, requesting, raising grievances, etc., right? So what does that really imply for organizations? How should they uh, you know prepare sort of front to back to deal with this?
Sure. I think one has to be careful because I don't want to be, catastrophist about this. But, we have seen quite a lot of political activism in India right now, right? We all know about the cockroaches, right? And that's an organized movement of people using various forms of protest. The DPDP gives groups like that and individuals another channel with which to both protect themselves and pursue their own rights in an entirely legitimate way, and also to weaponize those rights against organizations where they feel they have a grievance. And I think you have to be conscious of that. And there are in the particular implementation of data protection law that India has chosen, I think we have an extra angle to this. So there have always been what we call weaponized DSARs, weaponized data subject in the GDPR language access requests. This has commonly been disgruntled employees. So if you terminate someone in Europe or the UK, you can, and in fact now across the Caribbean and lots of other countries where they have a GDPR-like set of rights, you can immediately expect them to send you an access request asking for every piece of personal data pertaining to them throughout the duration of their employment. And this, because you have to redact that information to protect the interests of others who may be mentioned in it, and because you have to go through it to try and make sure you're not revealing anything that might subsequently be a problem in the inevitable employment tribunal that will follow, becomes a very significant burden. The preparation for that is good data hygiene in the first place. Don't retain data you don't need. Make sure you know where it all is. Try to avoid having data in unstructured repositories where you can, because it's harder to pull it out and harder to redact it. But also, it is a hearts and minds campaign about demonstrating transparency, showing that you care about your data subjects. And you can parlay all of that was in an employee context into exactly the same thing for disgruntled customers, disgruntled other correspondents over whom you have data. However, in India, because it's a consent first law, which is not globally unique by any means, but unusual, and certainly unusual for a country operating at this scale, there is a really interesting question about weaponizing the withdrawal of consent. So in other jurisdictions where you have a customer, most of your processing is either going to be on the basis of contract, so you are processing in service of a contract you have with them, and therefore the processing is legitimized by the contract and can only be delegitimized if the contract is terminated, and there will be contract termination provisions that protect you. Or you'll be processing on the basis of your legitimate interest in things like service improvement and business intelligence, which can be challenged, but there is no absolute right to object to it. The challenge in India is that most of that processing is going to be on the basis of consent. The consent wording in DPDP is still very similar to the sort of global standard from Convention 108. So it is fully informed and separated and all of the rest of it, which is already a challenge when the consent is necessary for contractual processing. But your real problem is that you're going to have to make sure your systems can cope with the difference between somebody whose contract is being serviced with their consent and whose contract is being serviced without it. You still have, and there's a whole piece in 6.5 in the DPDPA, the opportunity to continue to service contracts after consent has been withdrawn, but you can then only do the things that are strictly in the service of that contract, even if your consent previously contained within it umbrella provisions to allow you to do the other things that you might normally expect to do around offering people additional services, improving their service, measuring performance, all of that. So I think that is my biggest fear, if you like, is weaponized campaigns of consent withdrawal, particularly because this conceit of having centralized consent managers will make those campaigns much easier to operate, because you can encourage everybody who's in your political group to go to their consent manager and just bulk withdraw their consents from whatever sector of the economy you don't like that day. So I think that's going to be a really interesting area. The other thing that I would be alert to, and it's slightly broader than this consent point, is this relationships between fiduciaries and between fiduciaries and processors. This has been an area of increasing focus everywhere else in the world. Most breaches, as you know, originate in the supply chain. And increasingly, we have seen regulators and lawsuits holding fiduciaries to account for breaches in their supply chain and wanting to see the evidence that they did proper due diligence on their supply chain and that the agreements they have with the supply chain correctly attribute liability. This gets much more complicated when it's fiduciary to fiduciary. And the point that I was making earlier is much like the campaign to establish your bona fides and transparency to try to discourage weaponized rights exercises, you need to take ownership of the agreements between you and other fiduciaries and between you and your processors to avoid those agreements being imposed on you and to make sure that you are demonstrating that you are concerned about that due diligence across the piece. Because evidence of compliance is your best defense against everything that we've talked about, whether it's the board or a lawsuit or a data protection campaign by interested parties in the data principle world.
Got it. Maybe last couple of questions, and then we'll pick a couple of audience questions. So Sumandra, I think we spent a lot of time talking about the fact that the new world will probably step into starting May. And therefore, privacy needs to become a continuous sort of operational capability. So it's not necessarily a muscle most organizations had or perhaps even have right now, right? So how would you think about organizations preparing for this? So you're seeing it at your clients?
That's a great question, Malcolm. And again, one size does not fit all on this. Like I mentioned in the previous response, the first thing that you really need to gauge is your risk posture, right? And in order to do that, first of all, you need to understand what kind of personal data flows that you're dealing with. I see a lot of organizations struggle with that. And of course, there's numerous ways to do this, but there seems to be this hesitation or apprehension that how to start really. And it can be very simple. It can be an internal questionnaire to your departments, just asking, okay, what kind of personal data do we collect? Why do we collect? And how long do we store it? But organizations are still pretty hesitant. And the other problem that also is there is who's really going to take that onus. So therefore, the first thing that I would say organizations should do is look out for your privacy champions, right? Different verticals in your organization. Let people volunteer even that, they're going to pick up the responsibility to do this fact finding in order for the organization to set up some sort of a foundation. And gradually, once you've done that fact finding, then you move towards your internal governance limb that I was talking about, that you have at least some form of or a SOP by which you can figure out who in the organization is going to take up which roles. And then that will form the bedrock of figuring out the other compliances. Some of these will be legal in nature. Some of these will be technical, organizational, as well as information security perspective. But things that can run in parallel are that it's not that you should put off training or basic training for employees to to the date closer to when this law is going to come into force. These are things that can keep happening in parallel. That you not only have training sessions for employees in general, but also senior management, so that everyone has a buy-in into the entire process. Because again, of course, you have, let's say, a good set of privacy champions. But ultimately, they are going to need help when you start moving into the more granular aspects of implementation, right? Whether you do it internally or whether you do it with the help of external advisors. The reality of the matter is that a lot of the information has to come from the organization itself. And I think last but not least, um, what are you going to do in terms of record keeping? One thing I want to talk about is that while the Act does not talk about any records of processing activities, looking at the way the rights of data principals have been structured, if you do not maintain records of what is actually happening, it is going to be impossible to really comply with this law. So that is going to be another important aspect. Once you've figured out your privacy champions, once you've done basic training of employees, because that is going to be like a Bible document, which you will have to not only maintain but keep on updating once the law has been fully implemented. Back to you, Malcolm.
Yeah, thanks. Ben, maybe ask you the final one, and we'll take, like I said, a couple of uh, um, audience questions. Uh, I'm sure have you seen the cycle play out in other jurisdictions? Uh, I'm sure every organization would have taken a different path to get prepared, right? Perhaps some would have done crossed all, crossed all, dotted all I's, crossed all T's, on a very exhaustive exercise. Some might have taken a path where, you kind of do what's needed. But if you look back, maybe on a historic pattern and say, for organizations who probably fell short or came up inadequate, where would you say the areas they might have, in retrospect, perhaps needed to have invested more or spend more time on, if they were to do this, one more time?
Sure. I think there are probably two things to say. Echoing what Sumantra was saying, it is partly about separate work streams and separate responsibilities. Privacy is both a governance and an operational activity. And organizations that try to collapse all of that into one function tend not to get it right. So there's very clear legal separation in most privacy law. It's less well established in DPDPA, but this distinction between the Privacy Office, the internal operational function that does precisely the compilation of records of processing, the mapping of data flows, the day-to-day management of policy enforcement, the kind of staff support, the Privacy Champion program, all of those things, is distinct from the governance and audit compliance function that's represented by the DPO. So in a conventional model, the DPO is a quasi-independent operating unit. It's not an individual person. That's another mistake, is to think that one person can carry this for a large organization. But it sits outside the organization, between the organization and the regulator, and between the organization and the data principal, and it represents both sides to each other. So it is the data principal's champion within the organization, but also the organization's liaison and line of defense against the data principal. And it is the representative of the organization to the board or the regulator, and vice versa. It acts for the regulator to be the first line of enforcement of compliance. If you get that separation right, you have a much clearer sense of what the reporting lines are, because the Privacy Office is clearly an operational reporting line. It's often within the IT or IM function. It has a very close relationship with legal. On the other hand, the DPO is a risk management function that reports through risk and should report directly into the board, the small b board, the board of the company, to make sure that senior management really understands how good compliance is. So that would be point one. I think point two goes back to not putting enough resource into and not properly understanding that this is an organizational transformation program. It's not a paper exercise. So the classic failure is bringing in a consulting firm to produce a framework that sits in a box that looks really convincing, but is not actually acted upon. and then discovering, to everyone's shock and surprise, that this does not survive encounter with a breach, it does not survive encounter with a lawsuit, and it does not survive encounter with the regulator. You have to live it, not just write it. And living it is much more deeply embedded in the organization than a papering exercise. It is unfortunately, therefore, more expensive, which is why A, you need to start early so that you can spread the cost, and B, you need to see it as something that helps you generate business efficiency, not just as a compliance exercise, or nobody will sign the checks. And then they will look surprised when the very much larger than the check they were asked to sign fine turns up 3 years later. And one never wants to be in the business of saying "told you so," but we have had many encounters with organizations that really didn't want to make the investment and subsequently paid for it. So my kind of slightly predictable from somebody who runs a business like mine advice is start now, do it properly, make the investment, and then make sure you get the return on that investment. And that's where that operational focus really pays dividends.
Great. So I think we'll take a couple of audience questions in the interest of time, and then we'll wrap up. So Sumandra, and I'm going to pick a few, and to the rest we couldn't answer. We will get back to you, right? And I'll pick one for you, Sumandra, and one for you, Ben. Sumandra, for the one for you is there's a question around saying, will the Data Protection Board act the equivalent of sort of courts in India, and who will be eligible to appear before them?
Right. So, the board will have the powers of civil court naturally, because it is going to be an adjudicatory body. So, therefore, it will have that coercive power when it comes to investigations, when it comes to evidence, etc., because it functions as a court, right? While it is digital office, functionally speaking, under Indian law, it will have the same power as courts. In terms of administrative procedures as to who can appear, of course, the data fiduciary in question, officials from that or any organizations who have claims against them will have to appear. Now, in terms of legal representation through councils, etc., there could be further procedures which might be prescribed. But taking some ideas from other administrative tribunals, etc., that we have, it is not that you will be barred to take legal representation with lawyers. So I think pending more information on this, it is expected that in terms of parties can and will be able to also take legal counsel and other representation in terms of whatever proceedings there will be before the Data Protection Board. Malcolm.
Got it. Ben, maybe I'll pick a couple and ask you, and maybe I'll go one after the other. So there's a question saying, are in this I guess in the world of having to produce evidence, etc., are policies enough? Probably linked to some of what you had said earlier. Or just having policies now.
Policies are definitely not enough. You need, exactly as you'd expect. I mean, think about this from a financial audit perspective, right? You need to show end-to-end governance. You need to be able to demonstrate that your policies have actually been applied. So it's policies, it's evidence of training, it's underlying documentation, it's data protection impact assessments. It is some analogy of legitimate interest assessment, so that's much less a thing from an Indian perspective. But these are all evidence that you thought about it at the time. It's the minutes from your data governance committee. It is the chain of custody, if you like, in privacy by design. So the evidence that the Privacy Office was consulted when the idea to do the processing was first originated, and that their feedback was respected in the evolution of whatever piece of product or processing development you were doing. It is the ability to evidence your due diligence on your supply chain and your data sharing partners. It's the existence of intra-group data sharing agreements, of data sharing agreements with other fiduciaries, of data processing agreements with processors. So there's a whole body of evidence it all fundamentally sits on the record of processing activity. So exactly as Sumantha said, while this is not explicitly called out in DPD in the DPDPA, it is still the absolute foundation of privacy best practice. And it's why you need a good GRC system. This will make Malcolm happy, but it's true. You have to have somewhere to keep all this information that allows you to show that this is a living, breathing activity that you push through the whole organization. It's also, of course, the valuable repository of information about what information the business processes and who does it and why they do it and when, that you can use to inform much wider decision making about organizational data processing efficiency, about AI implementation, about new projects. So it's not just a compliance exercise, but if you don't do it at that depth, you don't have the evidence you need to satisfy a regulator or a court.
Thank you. Sumantha, maybe one more. There is a few questions around third parties, right? Shared data with third parties they could be all sorts of processors, I assume, right? Could run AI models for us, or contact centers, or whatever it could be. So, how do you think about, given how the law is and liability on the data fiduciary, how do you deal with that?
See, I think there's a few ways to do this, and from simple to complex. And the first thing again, and I talk about what is your risk posture, right? In your agreements, let's say you have your cloud provider on one side, and let's say you have a more simple vendor, right? Maybe who's just supplying you with some basic supplies, right? You can't have the same kinds of clauses that you're going to have for the first one that you're going to have for the second one. So you need to first have an idea what kind of third-party ecosystem that you have, right? Are these processors? Are these other data fiduciaries, correct? So that is one aspect. Then you grade them according to the kind of sensitivity and risk that you perceive. And then lastly, you think of the measures that you are going to take, both from your agreement side. Again, you will have different sets of clauses that you will want to insert based on the risk posture that you have with that third party. And of course, in terms of ongoing compliance, you can use a variety of methods. You can have questionnaires, asking them questions about how they process and how they safeguard data. You can have mechanisms for periodic audits and also extraordinary audits in case you perceive that there is a breach or a breach has been reported to you. So, there are variations of mechanisms that you can try. But again, the homework to be done here is, are you aware of the external ecosystem of third parties that you use, with whom personal data is getting shared, or even the reverse, that you are getting personal data from? So basis that, these are some of the aspects that you should be considering for compliance with the new law. Back to you, Malcolm.
Yeah, and maybe one, Ben, a quick one, just so that we pick up as many as we can. There's questions about this data deletion, right? So when you encounter data deletion, is it truly deletion? Is it retaining it because I might still need it for regulatory purposes, but not using it in a way I'm not supposed to use it? How do you think about that?
I think the first place I go when I talk about retention management is to remember that it's granular. So there is one of the things we see as the most common failure is, and noting here that the DPDP is a digital only act, so it doesn't come with the challenges of retention management in paper records that have been common elsewhere. But of course, we've been digital for some time now, so we still have data going back quite a long way. And people tend to look at this as black and white. They go, am I deleting this customer's records or not? And then somebody says, oh, but we might be sued, or oh, they might come back, or oh, we might still want to market to them, or oh, we still have a consent. And you say, well, okay, look at the totality of the data and work out which fields we still need. The example I use most commonly for this, because it's easy to understand, is employee bank details. While you employ somebody, you have to pay them. In order to pay them, you have to have their bank account details in order to send them the money. After they have left and you have paid them their last paycheck, you don't need the bank details anymore. You absolutely do need to retain all sorts of other information about them for varying periods of time, for tax reasons, for legal reasons, for potential, tribunals, to give references. There's lots of good justifications for retaining that information, but you don't need their bank details. If it turns out that you owe them some money and you didn't realize, they will give you their bank details again so that you can pay them. Trust me, they will. So that granular attention to removing or redacting specific pieces of information is the foundational aspect of operational retention management. It's why you have to bake it into your process. It's part of your employee offboarding that you remove the information you don't need. When it comes to that question about deletion, the standard answer has been it is deletion, although in many cases it ends up being redaction because you have systems that don't allow you to delete partial records. Take an HR system or a CRM. You don't necessarily want to delete the entire customer record, but you need to remove their payment information because they're no longer a customer. So you go in and you overwrite it with zeros if you're not allowed to delete it. What regulators have generally said is we want to see you have made the effort to remove the information that you no longer need from your live systems. We want to see that you have made the effort to ensure that you've logged that so that if you have to restore from a backup, you go back in and re-delete information that was restored that you no longer need. But we are not asking you to go through many years of legacy backups to prune out individual records. Right, so we've had customers panicking that they have to go back through, their grandfather, father, son archives of data, or that they have a journaling system that means that, they could theoretically restore data from 5 years ago. And we say regulators aren't concerned about that because there is a reason why retention management exists, and it is to minimize breach risk and to minimize the risk of you abusing data. If you have backups in cold storage, they are not a significant breach risk and they're not live data, so you're not going to abuse it. What's important is that you show that what you are retaining in your live systems is required and relevant.
Okay. So with that, we'll just summarize and wrap up. Thank you, Ben and Sumantra. So I think the whole point of the discussion was to say that we use various analogies, but it's the real sort of match begins in May, and of course, therefore, the time right now is to prepare. We think most of you and most organizations would have at least begun, but we do believe that as you think about it, you're probably in phase 2 now, and phase 3 probably is closer to May. So this is a quick. We won't go through each of the points here, but this is probably a quick glimpse of how one would think about it. Hopefully, everybody's through sort of phase 1 and in the midst of phase 2, as you then finally build up to getting to phase 3. Happy to, of course, share more details and exchange thoughts offline. If we go to the next slide. Yeah, I think with that, we'll wrap up. I'll quickly summarize and Ben, please add. So at least as was discussed in our interaction, this is then an enterprise muscle or capability that one needs to have post-May, right? I think as Sumantra described, the DPB is digital by design, therefore on-demand compliance, less paperwork, probably speed, and therefore speed on the side of all parties involved. I think accountability is clear, has to span lawful processing, security, absolutely oversight of third parties, as well as newer probably angles, right, including how data gets used in AI models, etc. And therefore, there is if this is a new muscle that you need to build, you need to sort of prepare now and get it right the first time. Ensures that, as Ben began to describe, there are no sort of regrets and look backs, no unnecessary exposure and long-term costs of rework. And therefore, if you're on the journey, great. Need to speed up. If you're just beginning to think about it, it needs a significant acceleration. So Ben, if you want to add, please do. Otherwise, we can wrap up.
Thanks, Malcolm. I think that's an admirable summary. I'd want to keep banging home this point that if you wait to see other people get punished, you will not be able to prevent yourself getting punished because you will not have been compliant from the get-go, and the regulator will look back. And we have heard people, and not just in India, we've seen this everywhere, you know, in a kind of wait and see posture, as if they think that they can wait and see, and then once they decide it's real, they can fix it then. And the answer is you can't, because the regulator grinds slowly, but they grind very fine, and they look at your organization's posture from the outset.
Okay, wonderful. Thank you, everyone. Thank you, Sumantra, for joining us. Thank you, Ben, for joining us. And obviously, like we said earlier, this is a series. Look forward to the next one in a couple of months or so. And like I said, we'll keep the dialogue going. For the questions we couldn't answer, we will get back. And feel free to reach out to us. Thank you.
Thank you.
Thanks, Malcolm. Thanks, everybody.